Hi, I'm Darren Findling of the Probate Pro, and today we're going to cover what is probate. Let's get right at it. Probate is often confused. It's confused with the words probation, and it is confused with the word pro bono, when in fact it has nothing to do with either of them. Probate involves matters that are subject to the probate court, involving the Estates and Protected Individual Code, the probate code. It can involve individuals who are alive or individuals who have died. For individuals that are alive, we're referring to things like guardianship, conservatorship, powers of attorney, as well as living trusts. Also, special needs trusts, trusts that are designed for people with certain disabilities and or Medicaid planning. For those who have died, we're referring to probate administration, probate litigation, trust administration, and trust litigation. In addition, survivorship accounts, accounts in which there is more than one name on it, and any will or trust disputes, litigation involving the admissibility of those documents. As we speak of guardianship, we're referring to a legal proceeding to determine that somebody lacks capacity to make decisions involving their own care, custody, and well-being. That individual could be an adult or it could be a minor. The probate court has jurisdiction over all guardianship-related matters. Now, it's important to understand that a guardian involves care and well-being. They don't get to handle money other than Social Security. And it's important to understand that a guardianship is different than a power of attorney. A power of attorney is a document created as part of an estate plan. A guardianship is a legal proceeding in which the court takes jurisdiction over that individual. A conservatorship, similar to a guardianship, is a legal proceeding involving an individual who no longer can manage their own financial affairs. Again, to differentiate between a guardian and conservatorship, we look at the root word. Guardianship, to guard over, care and well-being. Conservatorship, to conserve, conserving financial assets. A conservatorship can occur for an adult or for a minor. A conservatorship also is different than a power of attorney in that a conservatorship is a legal proceeding, as a power of attorney is a legal document that is done generally outside of the court. So a conservatorship is a legal proceeding under the jurisdiction of the probate court. A power of attorney is an effective estate planning document, different from a guardianship and conservatorship, which the court takes jurisdiction over the matter. A power of attorney generally is designed to avoid probate court involvement. It allows the principal, the person signing it, to give the authority to a third party. We call that person the agent or the attorney in fact. It allows them to make decisions. It may be a power of attorney for financial matters, and it may be a power of attorney for care-related issues. The probate court has jurisdiction when somebody has died for deceased probate administration. This is the process upon which you take the assets and the liabilities of an individual and you go through this step-by-step process orderly to get the assets and liabilities addressed and then eventually distributed. Now, a common misconception is that probate involves with a will or without a will. So even if you have a will in Michigan, we call that testate, or no will in Michigan, intestate, you are required to go through this probate process. Now, there are many effective ways to avoid the necessity of probate. To avoid this probate process, hiring a competent, skilled estate planning lawyer can guide you on probate avoidance strategies. In addition, if you're interested in more information regarding probate administration, I've done many videos on it, and there is a timeline below that I'm happy to share with you. The probate court also has jurisdiction over trusts, but not every trust requires the probate court's involvement. Let's examine this. When somebody is alive, there may be trust administration involving that individual's trust. That trust administration may be tied or dependent to their capacity, or it could simply be a trust that's being administered during their lifetime, regardless of their capacity. Now that trust may require the probate court's supervision, and it may not. And of course, if there are disputes involving the trust, it is the probate court that has jurisdiction over it. In addition, special or supplemental needs trusts, these are trust plans that are designed to effectively take advantage of government need-based benefits for those persons that are disabled. This is also part of the trust jurisdiction that the probate court has over these types of administrations. For those who have died, trust administration may also be occurring following the death of the settlor. And again, that trust may be required to have court supervision, and it may be completely independent of probate court administration and supervision. It depends on the trust language itself, or if there are disputes involving the trust administration. When there are disputes, the probate court has jurisdiction of those probate and trust litigation matters. The ones that you're probably most familiar with are will contest cases. Now, this contest can occur with a will, and it can occur with a trust. Whether that will was fraudulently signed, whether it was not signed by the decedent but forged, whether there was a lack of capacity of the person that signed it, whether they were under fraud, duress, undue influence. These types of matters go before the probate court for adjudication. In addition, what we call intra-family fighting, family fights that involve the will or trust within the context of those files, if there are disputes among the heirs or devisees or trust beneficiaries, it is the probate court that has jurisdiction. In addition, the probate court has determination rights over who the heirs are of the person that died. Think of this like paternity after death. The court makes a determination of who the heirs are of the decedent. And this can be quite important for certain benefits that may inure to the benefit of those people that are determined to be heirs of the person that died. Also, funeral and burial disputes. Who has priority to make those decisions? Should you cremate? Should you bury? And the decisions relating to those matters, when there's a dispute, the probate court has jurisdiction. In addition, if there's an attempt to remove a trustee or personal representative, you go to probate court. One of the most common forms of litigation are when a personal representative or trustee gets appointed by the court and they stop giving good, transparent, clear information about what's going on to the trust beneficiaries or the heirs or devisees of the estate. You want to hold that individual accountable. You may even need to ask for the court to remove them, or reviewing their fees or their actions, as well as asking them and holding them accountable to account to the probate court, as well as the heirs, devisees, or beneficiaries of the respective estate. I hope that this video has been helpful in understanding holistically what the probate court does and why the probate court gets involved in certain matters. If you're looking for a probate and trust lawyer that handles these matters, we're happy to have that conversation with you. You can reach us at theprobatepro.com or 833-PROBATE, and we'd be happy to discuss your matter with you.